Welcome back, class. We're talking today about legality of contracts. That's chapter 12 in the text. And we're going to start generally going back to our theme of how in the United States we promote entrepreneurship, we promote business, we want to support people and business people in their contracts. And generally, the courts will enforce contracts, your business agreements. And now we're just going to talk about some exceptions when they're illegal. For example, gambling is generally illegal between private parties. Now, this is a evolving part of the law. You know, when I was a kid, gambling was generally illegal, and now we have casinos in New York State. They used to only happen in Las Vegas when I was a kid. But so the trend you're seeing in United States law is we're even opening up the doors for gambling to take place. And you know, the lottery happened when I was younger. It existed for a while, and they were saying, well, if it supports education, then we should have the lottery, and we should get rid of these old puritanical laws. So there are laws that we call Sunday contracts, which were illegal back in puritanical days of the United States. So it was antithetical to entrepreneurship and doing business because we had these puritanical values that were sort of clashing with business values. And for a long time, we had Sunday contracts, also known as blue laws. So for example, when I was younger, and I think most of these are phased out in New York, but if you wanted to buy beer on a Sunday, you had to wait till noon, or no liquor or wine stores were open on Sundays. So I think that's all changed pretty much, and you're seeing a trend toward that. However, in the United States, you might run into a place where they don't sell alcohol at all. I've been to a dry county in Pennsylvania, not too far away from here. I've also visited Utah, where it's heavily regulated. So those still exist. And gambling is very well regulated. You know, these are trends that are evolving, but you still see illegal contracts based on these puritanical values left over in United States law. Next one is called usury, a concept of usury. That is lending illegally, charging too much interest to people that you're lending money to if that's your business. Now, generally in New York State, it's actually a crime to lend money and charge more than 25% interest. And I had a case involving an eviction when I worked for a nonprofit, and I was defending someone being evicted. And we looked at what they were claiming the money that was owed, and the late fees plus the interest combined to be over 25%. So I told the attorney for the landlord, I said, you know, not only are you charging way too much and it's unenforceable, but this is a crime in New York State. And he agreed with me, and he told his client to give them free rent for several months to make up for the illegal fees and interest, which essentially is a creditor-debtor relationship. If you're a landlord and a tenant, and the tenant owes you money, you're now a creditor. So usury laws apply. And the funny thing about that in New York State is that banks aren't subject to the usury law. So the exception is that banks, professional lenders, can get away with charging these exorbitant interest rates. But that's just my opinion. All right, next is an important concept which has to do with licensing. So if you're going to engage in certain types of businesses, you may, depending on the jurisdiction that you're operating in, you may need a license to do that. So as a lawyer, you know, I had to earn my license. I had to pass the bar exam. I had to go through character and fitness committee, and I had to earn my license to practice law. Okay, so you can't just go around practicing law without a license. And it's a felony to do so. It went from a misdemeanor to a felony in New York State while I was a lawyer. And that's because people were taking advantage of immigrants in New York City. They weren't attorneys that were charging them. And then if the person got deported, guess what? They were gone. They weren't a problem anymore. So New York decided to make, in recent memory, the crime of practicing law without a license it went from a misdemeanor to a felony, and we learned the difference about that in chapter 6. It's much more, you can go to state prison for a felony. You know, then it has to do, we're going to cover a case at the end of the chapter that sort of breaks this down a little bit, and depends on your jurisdiction. So if you're in New York State, you also have to be certified to do salon services. So cutting hair, or doing nails, things like that. Cosmetology is a profession that's covered under New York licensing, and same for nurses and teachers, and depending on the particular job, you may need to have a license. And if you contract with someone who's not properly licensed or certified, then it may affect the validity of a contract. It might be an illegal contract, or it might be partially illegal. The compensation rate might be affected. We'll get to that in the case at the end of the chapter. All right, illegal by common law. So we're talking about certain things like trade restraints, okay? Those are disfavored because we're in a capitalist country. Again, in the United States, we promote business, we want entrepreneurship. So a trade restraint, we're going to be skeptical of that. We're going to be critical. We're going to limit contracts that limit or restrain trade. So we use the reasonable standard to decide that. So an objective person looks at that. And in the restatement second, it's quoted as, unless the restraint that imposes is unreasonably detrimental to a smooth operation of a freely competitive private economy. So that's when a provision of a contract is going to go against that spirit of entrepreneurship. That the restatement second says, a smooth operation of a freely competitive private economy. That's what we're striving for in the United States. And so if you got a contract, normally we want contracts, we'll enforce contracts, our courts will enforce them. But if it's a trade restraint, we're going to look at it again. Does it impede on that spirit of a smooth operation of a freely competitive private economy? All right, sale of a business. So when I've done these, when you sell a business, you sell a couple of things. You sell maybe the building that it's in, or some of the assets that it has, some of the goods that are involved in the business. You're also selling the goodwill. So you're selling the reputation of the business. You're selling the customers of the business to an extent. It's a free country, so customers can go where they want, but you can't do anything to mess with the customers that are already coming in. That's called the goodwill of the business that you're selling. So a couple of lessons there I talked about in class, but I'm just going to cut this down to legality of a contract. When you sell a business, you sort of agree not to compete with the person you're selling it to. That's the goodwill. In other words, if you sell a barbecue, Bob's Barbecue, you sell it to someone, you can't go down the street and open up a new barbecue place and call it better than Bob's Barbecue, because you didn't really sell anything. You're taking your customers with you, and you're saying that you got a better barbecue. So what we do when we're buying and selling businesses is we negotiate a reasonable restraint on the seller's ability to open up a similar business or a similar business in a certain geographic area. And an unreasonable geographic area is going to change from place to place. So in New York City, for example, where you've got lots of customers, you got millions of people, maybe you don't open up a place within 10 miles. And then, upstate where it's very sparse, if it's a barbecue, let's say, maybe 50 miles is big enough, because, if you're the best barbecue place in 50 miles, that is what you're selling. But you got to agree on all that before you make the contract to sell the business. We've got employment non-compete clauses. So sometimes you make a contract, employment contract with someone, and you say, well, you can't work in the same business for the next couple of years after you leave here. Or you can't disclose secrets, things like that, or you can't share customer lists or research or methods or things like that. So as long as they're reasonable, they'll be enforced. On the other hand, if you want to be a dishwasher at a local restaurant, if they don't want you working at restaurants for 10 years after you leave the restaurant, that's going to be unreasonable. So you're going to have a tough time enforcing that contract. Then we've got the concept of unconscionable contracts. And that's where it just blows the mind to think that this contract would be valid. And we're going to talk about a case at the end of the chapter to sort of discuss how that goes. But generally, you apply public policy. We weigh the interests um, of capitalism and entrepreneurship versus public policy and what's acceptable in our society. All right, exculpatory clauses. And those are things where either part of a contract or as a contract as a whole, someone's going to sign off on certain rights, certain liabilities of the person who's asking them to sign it. And there's 6 factors outlined in Chapter 12, 12.3, the section under illegality by common law. And, they're disfavored by public policy. We don't want to, limit people's rights, but they're enforceable if they're reasonable. They're generally not regulated. Okay. So, I talked about in class the difference between a bike race and a bus route. So before you do a bike race, there's a lot of risks. It's an inherently dangerous activity. The person who's organizing the race, they can't regulate all the roads. I mean, they might be able to put some signs up, maybe get a few cops to direct traffic, but essentially you've got miles and miles of roads where you can't control all those drivers out there. Or there's other hazards I talked about, like a bicycle crash. You're coming down a hill and you've got, 20 bicyclists going 40 miles an hour. Well, if one person falls over, everyone's going to go. It's kind of like a domino effect. So they make us sign waivers before we do bicycle races, and those are generally going to be enforceable because of the risk involved and how much control over the person who's organizing the activity. So bicyclists who engage in a race are going to take on some of that liability. So an exculpatory clause that everyone's supposed to sign is going to be enforceable generally, something like that. We also talked about skydiving, cliff diving, things like that, scuba diving, things like that. They're inherently dangerous, and exculpatory clauses to an extent are going to be, while they're disfavored, they may be enforceable. Now, if you think of the other example, like a bus line, or if you're an Uber driver, it's going to be unreasonable for someone to have to sign a contract before they get in your car. So it's just not going to be enforceable. We also talked about restaurants. Generally a restaurant's going to take on the liability of serving their food and the risk associated with food poisoning. You can't expect customers to sign a release that they're not going to get food poisoning or something. That's just not going to be enforceable because it's it's just a standard kind of contract you have. You can't waive that kind of thing. It's against public policy. Let's see. Those things would have to be, obvious to people who are engaging in them. If they sign something, it's got to be obvious. I think you get the idea there. There's going to be contracts that are illegal, such as obstructing justice or violating public policy. Obviously, if someone's trying to bribe a politician or a public servant, that's not going to be an enforceable contract. Family relations, those, we want people to have general family relationships. We don't want there to be too much contract involved in that. So, prenuptial agreements are growing in popularity, and I think they're great because we've talked a little bit about divorce and how frequently divorces are dissolved and how much traffic they cause in the court. So prenuptial agreements, I think, are a good idea. On the other hand, they can be challenged. I mean, if there's certain provisions in a prenuptial agreement, a court will entertain whether or not it's valid. Custody agreements, for example, that those are family. People make contracts about when they're sharing custody with children, or someone might leave directives if they die about how to handle their children. I mean, those contracts are going to be respected, but we're going to look at it from a different perspective. We're going to say, is it in the best interest of the child? So, an agreement to watch over someone's children is going to be secondary to the authority of a family court to decide what the best interests of a child are. Let's see. Generally, there's a hands-off policy when it comes to contracts. I said just the general rules. We want to support business in the United States. We want people to make contracts and we want to enforce them. There's some exceptions, a party withdrawing before a performance. So, an illegal contract's not going to draw attention if someone decides not to do it. It's just a thought of doing it. Sorry, I just had a little glitch there. Parties protected by statute. So, think of pilots or truck drivers. They're contracting with their businesses to work maybe overtime, but it's in our interest to not enforce those contracts. We want to sort of keep the roads and our planes safe, and we want to make sure that contracts like that don't take place. A lot of the other stuff we've talked about in other chapters. There's the concept of excusable ignorance. So let's say someone contracts you with, they have a truck that pulls up to a building and they say, hey, I need help right away. I'll pay you whatever you need. I'll give you $50 an hour or $100 an hour, fine. And you're unloading these crates down to a basement. And then suddenly cops surround your job, what you're trying to do for $100 an hour. And you don't know this, but the crates are filled with methamphetamine. And it's an illicit drug, it's illegal. Well, you aren't going to be at fault because you didn't know it was in there. That contract for you could still be enforceable. The rest of the contracts, whatever the sale was and everything, that's not going to be enforceable because it's illegal. Moving on to the cases in 12.5, we've got extension of statutory illegality. And the case there is Bovard versus American Horse Enterprises. That's a case in 1988 in California. And I believe cannabis is now legal recreationally in California. If it's at least I think it is legal there. But back in 1988, it wasn't. And what you had was Bovard suing American Horse Enterprises for some promissory notes that they had and that's a promise to pay a certain amount of money, and it's a cause of action in court if someone fails to do that, and you can attach ownership, a lien on a property, for example. And that's what they're trying to do here, except that the court said, this American Horse Enterprises, let's look into this business. It's supposedly a jewelry business, but the only real jewelry seems to be roach clips and bongs for cannabis, which is illegal. So they said that contract is not legal to begin with, and they refused to enforce it. Next case is Venturi and Company versus Pacific Malibu Development. And I talked about, the importance of licensing in your jurisdiction. And in this case, you had Pacific Malibu Development wanted to develop some property in the Bahamas, and they needed to get financing to do that. And they had an agreement with the plaintiff, Venturi, to get financing. And Venturi went and checked at least 60 banks to get financing over a 2-year period and was not able to get it. And just before Pacific Malibu decided to scrap that contract, they did get financing themselves, but they were under that contract with Venturi. And what they said was, Venturi is not licensed to be a broker. And we talked in class about brokers and agents, and it's a well-regulated business, especially in New York State. When I do real estate transactions, there's generally a broker involved. So the buyer of a property and the seller both hire agents. And when you see for sale signs in front of houses, that means someone has a contract with that agent to sell the house. And then when people are looking for homes, they have their agent, and then the agents get together and they take a bunch of the money from the sale, and that's how they make a living. but you have to be licensed to do that because you have to understand contract law. And, people who are agents or brokers, if they make a mistake with that license, they can be liable. And that's why there's a lot of brokers and agents work not independently, but they work for an agency, because the agency is going to have insurance. They're going to have a lot of leads. You're going to have lots of ways to do business with people, lots of relationships. And it's a well-regulated industry. And in this case, the court recognized that. They said, the supposed agent in this case doesn't have a license. Now, what they did was the appellate court went ahead and did award some money to Venturi, because Venturi spent 2 years, did look at 60 different banks, lenders. However, they calculated a fee that was much lower than what was bargained for. They said that, well, we're not going to give you the cost of what an agent would charge, but we will give you reasonable compensation for the work that you did. And that was how the court sort of split the baby in that case. But last case is Williams versus Walker Thomas Furniture Company. And that's a case from Washington, D.C. in 1965. You had a single mother raising 7 children, and she gets some items for her home, some furniture, some lamps, things like that, tables. And it's a rent to own agreement. So, she has a fixed income. I think it was something like $268 a month. So she wasn't in a position, it would take several months of this money, in addition to feeding the children and paying rent and everything like that, to get the furniture. So she entered into an agreement, went a few years and paid off a lot of the furniture and stuff. And then some business person, knowing that she has a limited income, talked her into buying some more stuff because she was getting close to paying off that original debt. She just a small balance. And they talked her into buying a stereo that costed something like 2 months worth of her income. And because of the payments that she was making on the old furniture and the new items, including a stereo that she really couldn't afford, what they did was, the way the contract was arranged, the payments would be applied not to the old stuff and then to the new stuff, so she could keep the old stuff, but they were applied pro rata. So she still owed money on the old stuff for, while she was getting close to paying it off. They locked her into an agreement where only some of the money that she made a payment for was going toward the old stuff, and it kept a balance. So the company had the right to repossess everything under this contract. Well, this is the concept of unconscionability. The court said, no way, this is against public policy. You're a predatory lender. You're taking advantage of her. You know what her income is because she has to disclose that to you to get credit to buy this stuff. And what you did was, when she was just about to pay off the stuff and be able to keep her old furniture, you took advantage of her. You talked her into buying the stereo that she can't afford. And that contract was ruled unconscionable under law, and it was ruled illegal. That's the general nuts and bolts of Chapter 12 that'll be on the test to supplement what we covered in class. And we'll see you for Chapter 13.